Welcome to the Don't Feed the Fear podcast, where we dive into the complex world of food allergy anxiety. I'm your host, Dr. Amanda Whitehouse, food allergy anxiety psychologist and food allergy mom. Whether you're dealing with allergies yourself or supporting someone who is, join us for an empathetic and informative journey toward food allergy calm and confidence. Welcome back to the Don't Feed the Fear podcast. This spring, we are continuing to talk about all the things that we don't want to talk about, but that are important for us to have open conversations about. Today, the thing that I really don't want to talk about is politics. But unfortunately, current politics are potentially affecting the food allergy community in ways that we didn't expect. So today we are joined once again by a friend of the show and food allergy attorney, Laurel Francoeur, who is here to help us make sense of a major federal case that's been playing out, Texas versus Becerra. This is a lawsuit brought by 17 states challenging the federal guidance around Section 504 plans. While kids with food allergies were not intended to be the target of this state's lawsuits, these plans are important for many of our children to stay safe and included at school. So while right now the case is currently on hold, it really raises big questions about how disability rights and the needs of people with medical disabilities are being interpreted and protected at the federal level. So, full disclosure, I was so excited to get Laurel's take on this, and she and I really enjoyed chatting with each other. We didn't realize until we were finished that we really jumped right into this conversation without laying the groundwork or defining some of the terms that we used. If you aren't already familiar with these concepts, here's a quick primer to help you follow along. 504 refers to Section 504 of the Rehabilitation Act, which protects students with disabilities and ensures that they get the accommodations they need in schools. Food allergies are one of many disabilities that can be accommodated under Section 504. ADA is the Americans with Disabilities Act, another key law protecting people with disabilities from discrimination. IDEA, or IDEA, is the Individuals with Disabilities Education Act, which guarantees special education services to eligible students. An IEP is an individualized education program under IDEA, while a 504 plan is a support plan under Section 504. Both are legal tools that schools use to meet students' needs depending on their individual situations. And OCR is the Office for Civil Rights, which is part of the federal government's Department of Justice, DOJ, and is responsible for enforcing civil rights laws in schools and other public programs. So this episode is an invitation just to stay up to date, to understand what's happening behind the scenes and why it matters so much for families like yours. We don't want to cause an uproar. We just want everyone to be aware, because the uncertainty of what's going on can be quite distressing for us. It's still up in the air, but here is Laurel Francoeur to talk to us more about where things stand at this moment in time. And I'll preface this episode by saying, if you missed our first conversation on the show, it might be a good idea for you to pause and go back to listen to that first, because Laurel gives a more thorough background of the laws that apply to food allergy rights. And that was Episode 7, which was published in October of 2024. So if you feel very unsteady about those concepts I just defined, you might want to stop and go back and listen to that episode first. And without further clumsy description from me, here is Laurel Francoeur to help us understand what's going on at the current moment.
It started with DOJ because they put a pause on all new cases at the Department of Justice. So the Department of Justice, they enforce the ADA. So they enforce the ADA at school, they enforce it in public places, employment. So they basically said, we're not going to take any more cases. OCR is gutted, so they're pretty much stopped working. DOJ lost 70% of their lawyers, and so they had a pause on taking new cases. I emailed them earlier this week, and I normally get a response back, haven't gotten a response back.
Okay. And for those who aren't sure, the ADA is the Americans with Disabilities Act. ADA is for anyone who has a disability, including a food allergy, that the law would apply to protecting them as a person with a disability, right?
Right.
Okay. So the DOJ enforces the ADA.
Right. Okay. And they've been on pause. And then they just got rid of 70% of their workforce. And they're changing their priorities, so they're no longer focusing so much on disabled people. They're focusing on anti-DEI and transgender issues.
And for those who don't know, DEI is diversity, equity,
inclusion.
It sounds like you're saying they're shifting away from people with medical disabilities and needs and focusing on particularly transgender people, right?
Right, right. And so then that's where the Texas versus Becerra case came in.
Which is what a lot of us in the food allergy community are hearing about, and which is confusing because now it's Texas versus Kennedy.
Just because they were suing the head of HHS, and so
So
HHS
that's
to be a guy named Xavier Becerra, and now it's Kennedy. So
okay.
that's why the name is changed to Kennedy.
Okay.
But on the official docket, it's still listed as Becerra.
Walk us through that. It started with Texas. What are they claiming, and what is happening with the most recent hearing that you told me about that was in April?
So what happened was the HHS under the Biden administration put in new regulations about 504. And it said things like reaffirmed that it has to be in the most inclusive environment and certain other things. But as the example, the HSS used transgender or gender dysphoria as a disability. So that freaked out 17 states' attorney general because they said we don't want to have to not discriminate basically against people with gender dysphoria. And so they filed a lawsuit. So they said that those new regulations are unconstitutional. But then they went so far as say 504 in and of itself is unconstitutional. So they wanted to get rid of all of 504. And so there was a huge backlash. A lot of disability groups had their members write to Congress or, protest and so forth. So they just had a filing in April, and they said they're no longer challenging 504 in and of itself as unconstitutional. So they're saying we're only concentrating on this one context, meaning the transgender or gender dysphoria context.
Okay.
But they didn't withdraw the part of the complaint that makes it unconstitutional. So that's still in front of the court. They're just saying we're not pursuing it, but they didn't withdraw it.
Okay. So that's still in the language and it's written into the case all
So
the same.
they still have a count for 504. It in and of itself is unconstitutional. They're saying we're not pursuing that count anymore, but they didn't dismiss it. And then they're still pursuing this least restrictive environment, rather. Mm-hmm. They're saying that that's not part of 504. So that places shouldn't have to worry about putting people in the least restrictive environment. So, for instance, with a person with food allergies, if they could be accommodated in the cafeteria where they can be with their peers, that would be great, as opposed to making them eat in the nurse's office where they're separated by themselves. And that has been part of 504 law. And now they're saying that part is not constitutional.
Yeah. And my education, initially, my psychology training was in school psychology. And that's the biggest central concept to everything about addressing needs, learning disabilities, medical needs in the school environment is the least restrictive environment means we don't have to remove the child any more than necessary to meet their needs. It's helping kids to be included to the maximum extent that they can, which obviously benefits everyone. That's our whole special education system is designed and built on this concept. It's huge.
Yep. So that's still part of the lawsuit.
I'm sure there is legal terminology for this, but that would open the window for if you have a need that needs to be met, we can just seclude you and cordon you off in order to meet that need. Or is it that we don't have to meet it at all?
So they're basically saying that shouldn't be part of the calculation. So you shouldn't have to bring that into the calculation. But so we have two different tracks here. We have what the federal government is doing, and then we have the courts. So if you go into court, the court is still going to say that the least restrictive environment is the standard because that's based on their own case law and precedent and so forth. Okay. Unless this case says that that's all unconstitutional. Then you have what the federal government is doing, and they're choosing not to enforce certain parts of civil rights law and disability law now. So, for instance, OCR had 12 regional offices. They got rid of 7 of them. They have
civil rights for people who don't know.
Civil rights as part of the Department of Education. In the past 3 months, supposedly they've dismissed 90% of all disability cases that have come before them. They have stopped updating the OCR website. So usually the website will tell you which investigations are pending. They've stopped updating that, so you have no idea what cases are pending anymore. And they cut the staff. So the staff that is remaining is basically saying we can't do our job because it involves investigations and we don't have the staff anymore.
Right.
One of the OCR employees said their caseload went from 60 cases to 380 cases because of the regional closings. And then parents are saying that they're not getting phone calls back. They're not getting updates on their current cases that are pending there. People aren't answering the phone, supposedly. It's horrible. Now, there is a lawsuit brought by the Council of Parent Attorneys and Advocates, or COPA, saying that this is wrong, that the administration doesn't have a right to curtail the money that's gone to OCR and curtail its priorities. But that case has just begun. So that's going to take a long time to go through the
And then
wheels of justice.
what avenue does that case go to? Who hears that?
That's in federal court. It's in DC, the federal court in DC. So they're basically saying that what's been happening to OCR is not authorized, that Congress intends for it to be a working organization and for money allocated should go towards it. But they want to get rid of the entire Department of Education. They said they would put disability complaints with the Department of Justice. Now they're saying they might put them with HHS, Health and Human Services. So they haven't decided where. If they close it, they would put disability complaints. But if you put it in either one, those organizations are already overwhelmed.
Give people an idea of what kind of cases we're talking about. What's an example of a parent or a family who might have a case that's pending or that's not moving through because these are cut down so drastically?
So a parent who has a child with food allergies who's looking for accommodations and has been denied accommodations, or has a 504 plan that's not being enforced by the school. So those are the types of cases. And discrimination, bullying against people with food allergies.
So basically, if your child is unsafe at school and the school is not responding appropriately, this would be your avenue for taking action, and it's all but eliminated.
States still have anti-discrimination rights. The problem is most state departments of education only enforce IDEA, which is for like IEPs. They don't have the power to enforce 504. So what's going to happen is if OCR is no longer enforcing 504 and the states cannot, because they're not set up to enforce 504, then your only option is to go to federal court. Okay. And that takes a long time. Right. So I have one case, it's a food allergy case, but not involving schools, but it's in federal court right now. And we filed a motion in October. We haven't had a decision yet. So federal court moves very slowly. Right. So that was the whole idea of OCR, was to be a quick process, because if you're in school, you need a decision right away. I mean, you don't want a decision 4 years from now when you're no longer in school. Right. So now that's basically your only remedy.
Right. People get confused about the difference between IEPs and 504s, but IEPs cover for kids who have a learning disability, one of the categories of a learning disability. Most kids with food allergies, if they don't also have a learning disability, would fall under the category of 504, which is a medical disability rather than a learning disability. So what you're saying applies to most of us, or at least many of us that have kids with food allergies who have 504 plans in the schools, correct?
Exactly.
Okay. What's the next step for the Texas case?
So the attorneys general are trying to decide whether that's enough for them to be satisfied and don't need the case, or whether they still need to bring the case. So I don't know how long that'll take. I think their next check-in is in July with the court.
Okay. You had said after there was some pushback from people pointing out how this might affect things very widely, even though it was really a discussion specifically about how to handle transgender issues. When people spoke up about how this would impact other issues, including people with food allergies and 504 plans, the attorneys general of these states raising these cases said really that wasn't their intent. But you said that it's still written that way, even though they're saying their intent is really specific to how to handle transgender issues as they arise in schools.
Right, right. So one of the counts in the complaint, what they call count 3, is saying that asking the court to find 504 unconstitutional, full stop, that their law in of itself is unconstitutional. They have written in their memos saying that we are no longer seeking that relief, that they're not actually looking for it to be unconstitutional, the entire 504, but just in this one context.
Okay.
However, they haven't withdrawn the actual complaint. So they've said we're not going forward with it, but they haven't removed that count from the complaint. So it's still in the complaint.
They can remove that specific count. They can amend it as it's written, not just withdraw the whole piece. But
Right. So they could take out that one count. They could dismiss that one count and keep the rest of the complaint going.
Okay.
So I don't know why they didn't choose to do that. I don't know why instead they're saying we're not pursuing this claim.
Right.
I don't know why they didn't just get rid of it.
I see. What would you recommend that people do if they want to speak up?
So ask for your attorney general to get out of the case completely.
Okay.
Because even if you get rid of that count, they're still asking for the least restrictive environment language to be stricken. So unfortunately, the rest of the case would still be pending even if they got rid of that one count.
And still definitely impacting our community then.
Oh, yes, yeah. Yes, everything is on pause right now. And it's on pause basically because the president signed an executive order saying we're no longer going to enforce trans rights. The states are trying to decide whether that's enough for them, enough of a win for them, or whether they need to still continue fighting the case. So that's why it's on pause. So they're all assessing that part of it.
And that is another thing that I think many of us get confused about. How does an executive order require or demand the changes that are involved? It just seems like it's such a more complicated process than that. It's an executive order, not a law, right?
Right. But so every administration sets its priorities. Mm-hmm. So, for instance, the Department of Justice, Civil Rights Division, they enforce the ADA. So each administration decides what priorities, because obviously they don't have enough staff to handle every single ADA case or every issue that comes. So they prioritize. So in the past, the priorities have been people who are racially discriminated.
Gender discrimination.
Right. This administration has said those are no longer our priorities. Our priorities now are basically anti-DEI and keeping trans people out of sports. And allowing the religious schools to get vouchers and things like that. That's a case in front of the Supreme Court right now, whether religious schools can get state funds. With OCR, for instance, the way they're not enforcing it is by getting rid of the people. So originally, they fired a bunch of people at OCR. The court stepped in and said, you can't do this. You have to rehire these people. So what happened was they rehired them briefly, but then decided that they were going to get rid of entire departments. So then they said, well, we're not firing the people, we're reorganizing and we're getting rid of departments. So they essentially got around the court order that way. And with Department of Justice, they started sending memos to people saying you could take an early retirement and get a severance pay. But then they also sent memos around saying our priorities are changing. And so a lot of the lawyers who'd been there for years, over 100 of them, decided these aren't the right priorities and quit. Mm-hmm. That's how they get around it, you know.
Right, they quit. They chose to quit, right? But they set the tone with all these executive orders. That you're helping me understand it better. They're saying this is how we're going to play things out, and this is going to be the intent. So they kind of did that in order to set the precedent for all these people before these offers were made of early retirement or resignation. The underlying tone is if you stay on, you have to be on board with what we're going to enforce and how we're going to approach it.
Right. And so then the administration issued an order asking all federal agencies to stop enforcing cases based on disparate impact. So what that means is under disability law, you can have a policy that isn't discriminatory on its face, but it still ends up being discriminatory towards a group of people. So it has a disparate impact on one group of people versus another. That's always been part of the disability law calculus that you look at, has there been disparate impact? But now all federal agencies are supposed to reassess their cases involving disparate impact and possibly dismiss them and not enforce this going forward. So what that means is now, in order to show discrimination, you have to show intent to discriminate, not just that the policy itself ended up discriminating.
Right, which I imagine legally is hard to
It's
demonstrate
very
someone's
hard.
intent.
It's very hard. Yeah.
All right. So that's
Yeah.
another complication then that could affect cases, anything regarding cases where food allergies were discriminated against. If it wasn't intentional, if we can't prove that it was intentionally discriminatory, then those cases might not be heard. Is that correct?
Exactly. Exactly. I mean, they would still be heard in the federal court, but this is the federal government's agencies that are enforcing. So, like DOJ, the Equal Opportunities Commission, Equal Employment Opportunities Commission, EOC, or organizations like that will stop enforcing it.
I see. Thank you for explaining it all the different levels and departments and state and federal and how it's all connected is quite confusing to a lot of us. So it's hard to wrap our heads around. But basically it's just another very wide-reaching policy that could impact us specifically as individuals with a medical disability, right?
Yes. Yeah.
You had mentioned something positive to me about a new committee, and I would love it if you'd share that with everybody because we need to hear about some potential wins.
HHS is now forming an allergy committee to look into allergy issues and how they should be handled. And the woman who's heading it is somebody who's prominent in the food allergy community, and she's very good with the issues and understands the issues. So I'm sure that they will end up doing wonderful things. So keep your eye out for that. Hopefully, they will be public soon.
Another promising thing that is state specific, but you have so much experience with this. I would love it if you would comment on the initiative that's building in California with the proposed law to require labeling of the top allergens on restaurant menus. And I know you had some similar work in Massachusetts in terms of discussing these issues. I'd love your take on that topic.
Yes, so Massachusetts was the first state to have a law regarding food allergies in restaurants. The initial law was going to include that the restaurants should list all of their ingredients. So the proponent of the bill was Ming Tsai, who had a Boston restaurant, and he had what he called the Bible, which he had all of the ingredients of all of his recipes listed in. So originally the bill was written to require restaurants to list all of their ingredients. There was pushback from the National Restaurant Association and the Massachusetts Restaurant Association because they were afraid that they would be giving away proprietary recipes. So they didn't want to do that. So a compromise was reached wherein if you ask a server, are there, for instance, peanuts in this meal? They have to tell you whether or not there are peanuts in the meal. They don't have to tell you all of the ingredients, but just if there's what the allergen that you're asking for. So that's why you see on the menus, please ask your server if you have a food allergy, or please alert your server. So that means that if you want to get questions about an allergen in a meal, you tell the server and ask them, and they have to reveal that.
I see. They don't have
So
to write it on the menu, but they have to disclose it if you ask.
right, but they don't have to disclose everything.
Mm-hmm.
Just if you say, are there peanuts in this, they have to be able to say yes or no.
Does that apply only to the top allergens, or is that any specific ingredient? If I said I'm
It's
allergic
any allergen that you ask for.
okay.
Yeah.
Are there other states since then that have similar laws?
A bunch of states copied Massachusetts. So Rhode Island, I'm not sure if Illinois did, but a bunch of states copied Massachusetts restaurant law. So in many states now, you'll see that disclaimer on menus. Please inform your server if you have a food allergy.
Okay. Based on your experience with the formation of that law, how realistic do you think it is that we could have menus with the top allergens labeled? I know in Europe, they've been doing this for a decade. Do you think it will happen here? And what do you think the barriers to it will be?
It depends on how much pushback they get. So if the restaurant association again says that they don't want to have to disclose, that might be some pushback. Another issue, I think, is that restaurants fear that if they make a positive statement about, like, for instance, this meal is peanut free, then they're going to incur more liability than if they just said nothing. So I think restaurants are sort of afraid of that. However, they really shouldn't be afraid of that because in most states there's strict liability for restaurants that serve something to a customer that's harmful. So they're going to be liable regardless. I think the fear is if we hold ourselves out as this dish is peanut free and it turns out it's not, then they're going to be more liable than if they just hadn't said anything.
And you had mentioned that when you were talking about this in Massachusetts, there was an attempt to clarify what it would mean for a restaurant to be allergy friendly.
Yeah,
And
part of the law said that there'd be a commission to determine what an allergy friendly restaurant would be, and so restaurants could declare themselves allergy friendly. And I was on the committee and we met a couple times and we couldn't decide what allergy friendly would be. Would it be you check the ingredients every month, every week, every day? Would you have to go back to your supplier and ask them if their ingredients have changed? So we really couldn't come to a consensus on how you would define a restaurant as being allergy friendly. So that part of the law just never got implemented.
I see. With a good intent, but difficult to clarify, especially legally. Which reminds me of another topic. It's encouraging that more and more states have stock epinephrine laws. I'm excited that in my state, in New York, last year, they passed a law requiring stock epinephrine at public venues. Would you just talk about that trend a little bit too, and what your thoughts are on how those laws are written and what they could mean for the future?
Sure. So with those laws, there are Good Samaritan provisions in them. So that means that if somebody gives an EpiPen and has good intentions, but something goes wrong, they're not going to be able to be sued. So that I think should allay a lot of the fears that people have about having stock epinephrine and giving epinephrine in an emergency situation. However, I think a lot of people are still afraid. So in Massachusetts, we have a regulation that says the school nurse may train teachers on how to use epinephrine, but it doesn't say shall. So I've had some school districts where none of the teachers have wanted to be trained. They just said, we don't want to bother. And when I tried to find out what was behind that, I think it was this fear that it's a needle and it's a complicated procedure, possibly, and just sort of the fear around that. And they don't understand that EpiPens are designed for lay people. They are designed so that people can give them to themselves, and it's really not that difficult to do. But I think there's still this fear of it being a needle, and what if I do something wrong? Or
I agree. I see that in patients too, as far as people hesitating to use their epinephrine. There's something about that needle and that device that's really intimidating. So I think this wave of needle-free options that's on the horizon with Neffy, being the first to be approved here in the US, I think it really could change a lot, both with people's emotional experience and maybe legally, hopefully.
oh yeah, I think it's a huge game changer. Unfortunately, a lot of the laws, like the stock epi laws, are going to have to be rewritten because they mention auto injectors.
Right.
So a lot of those laws will have to be rewritten to account for other means of administration of epinephrine.
Right.
But
Which
that's not a big deal.
it's not a big deal. I assume it's just a small change to the wording, yet a whole lengthy legal process to accomplish that. Is that
Yeah, yeah.
the case? All right. Well, can you think of anything else that you want to leave people with in terms of all of these legal changes on the horizon and in the public discussion these days?
It's frustrating right now because we're in a time of change and we don't know what's going to happen.
Mm-hmm.
We have all of these issues that could threaten our rights. Guy who's in my office, another lawyer, has basically said we have to tell clients, suck it up.
Mm-hmm.
And as lawyers, we don't like this. I mean, he was kidding, but as
Right.
lawyers, we don't like to say that. We want to have an answer. We want to be able to say, yes, you have a remedy. And right now, it's unclear how this is all going to shake out. So
Yeah.
we just sort of have to wait and see and be vocal and speak up and contact your legislators, contact your local people, and ask for these things to work out. And hopefully that pushback will be enough to change things. But
Thank you for sharing that. I've been feeling the same a lot in my work in therapy sessions with clients and people being impacted in so many different ways. And I'm saying a lot of the same in terms of using our voices and speaking up when we have the time and the energy. So thank you for that
Well, you see a
encouragement.
lot of protests now, people protesting every day, whether it's at Tesla or Social Security.
Mhm.
So, and they are having effect, and the courts have been helping too. The courts have been giving us good rulings, saying that some of these things are not allowed, that you can't take certain funding away.
Yeah,
So there is some hope.
good. So keep speaking up. And you mentioned particularly speaking up and giving a face to the issue, a specific scenario, not just a general idea, right?
When you do talk to your legislators, make it personal. Tell a story. They respond much better to stories of how it's impacting you rather than just general principles. So if you say this law or this procedure that's in now is going to affect my child this way because X, Y, and Z, and really make it a personal story, I think you get a lot more traction with that. So I always say make sure you make it personal and let them know that this is really affecting their constituents.
Thank you for that. I hope that people will continue to do that and hopefully we'll know more in time here and things will be clearer in terms of what the impact might be. But in the meantime, I appreciate your feedback and your insight about all of it.
Oh, you're welcome.
Here are 3 things that you can do after you finish this episode. Number 1, as I mentioned before, go back and listen to the previous episode that Laurel and I did. It's episode 7, released in October of 2024. That's where Laurel broke down the basic legal concepts and how they apply to food allergy families. It's a great foundational companion to this very specific topic covered in today's episode. Check in with Laurel Francoeur's blog. You can find her at theallergylawyer.com and link to her blog from her main page. Number 2, I'd suggest that you learn more about and connect with the Council of Parent Attorneys and Advocates. They are actively working on this issue and offering resources and updates and information to help families advocate effectively. You can find them online at copaa.org. Their Instagram account is COPAAFAPE, Council of Parent Attorneys and Advocates. You'll also find their Facebook page under the same name. They're very easy to track down and putting out a lot of helpful information. And finally, number 3, FACT, FAACT, which is the Food Allergy and Anaphylaxis Connection Team, has created a great page celebrating Section 504, encouraging people to share their stories and to help with advocacy by showing the impact that 504 plans have in our lives. The address is too long to repeat, but I will put the link in the show notes as well as the notes for the previously mentioned things. But you can also find it easily if you just search for FAACT Celebrate Section 504. This was a tough conversation, but I do feel like it's important to know what's going on and what's potentially affecting us and have the chance to get involved if we choose. And I'm so grateful to Laurel Francoeur for helping us to navigate it with clarity and a little bit of calm, even though it is a confusing time. The content of this podcast is for informational and educational purposes only and is not a substitute for professional medical or mental health advice, diagnosis, or treatment. If you have any questions about your own medical experience or mental health needs, please consult a professional. I'm Dr. Amanda Whitehouse. Thanks for joining me. And until we chat again, remember, don't feed fear.